this video, we will be discussing two Malaysian cases that demonstrate the extent of application of common law and equity in Malaysia under Section 3 and 5 of the Civil Law Act 1956. These two cases come from very different areas of law, but they share the same legal foundation, that is, the use of English common law when there is no clear local written law. For now, let's kick things off with the interesting case of Kasvi MPPL Anor 2022 12 MLJ 2-P, which involves a family law dispute concerning paternity and the welfare of a child. This case is important because it shows how the Malaysian High Court applied English common law and equitable principles under Section 3(1) of the Civil Law Act 1956 to fill a legal gap, particularly in deciding whether a court has the power to order a DNA test on a child. This case will be explained step by step, in a simple way, using 6 elements: the facts of this case, issues, decision, ratio decidendi, stare decisis, and the overall judgment.
Brief facts of the case. The parties in this case consisted of the plaintiff, known as Kias, who claimed that he was the biological father of a child born to the first defendant, MPPL, who was married to the second defendant at the time. The second defendant in this case, Anor, is the husband to the first defendant. Both plaintiff and the first defendant worked for the same airline and had been in a romantic relationship before and during her marriage. The child was born while the marriage was still valid, which meant that under Malaysian law, the husband was presumed to be the legal father. Kias, the plaintiff, claimed that he had a sexual relationship with the first defendant during the possible conception period, maintained contact with the child for several years, and financially supported the child. He therefore applied to court for an order to compel a DNA test on the child to determine paternity. The defendant strongly opposed this application. The key difficulty of this case was that Malaysia has no written law that clearly allow courts to order DNA testing on a child in civil cases. Legal issue related to common law and equity. The main legal issue, relevant to common law and equity, was whether Malaysian courts had power to order a child to undergo a DNA test to determine its paternity. Since the issue is about Section 3(1) of the Civil Law Act 1956, let us recall our memory. Section 3(1) of the Civil Law Act 1956, which allows Malaysian courts to apply English common law and equitable principles where 3. There is lacuna, gaps in the local system. There is no contrary to any provisions of any Malaysian written law. And 3. The application is suitable to local circumstances. Non-related factual disputes were ignored for this question. Decision on the issue. The High Court ruled in favor of the plaintiff. The High Court held that it does have the power to order a DNA test on a child by relying on English common law. As applied through Section 3(1) of the Civil Law Act 1956, the judge exercised the court's inherent jurisdiction as parens patriae, meaning the court acts as a guardian to protect the welfare of children. Since no Malaysian statute governed this situation, the court lawfully turned to English common law principles to fill the legal gap. Brief facts of the case. The parties in this case consisted of the plaintiff, known as Kias, who claimed that he was the biological father of a child born to the first defendant, MPPL, who was married to the second defendant at the time. The second defendant in this case, Anor, is the husband to the first defendant. Both plaintiff and the first defendant worked for the same airline and had been in a romantic relationship before and during her marriage. The child was born while the marriage was still valid, which meant that under Malaysian law, the husband was presumed to be the legal father. Kias, the plaintiff, claimed that he had a sexual relationship with the first defendant during the possible conception period, maintained contact with the child for several years, and financially supported the child. He therefore applied to court for an order to compel a DNA test on the child to determine paternity. The defendant strongly opposed this application. The key difficulty of this case was that Malaysia has no written law that clearly allow courts to order DNA testing on a child in civil cases. Legal issue related to common law and equity. The main legal issue, relevant to common law and equity, was whether Malaysian courts had power to order a child to undergo a DNA test to determine its paternity. Since the issue is about Section 3(1) of the Civil Law Act 1956, let us recall our memory. Section 3(1) of the Civil Law Act 1956, which allows Malaysian courts to apply English common law and equitable principles where 3. There is lacuna, gaps in the local system. There is no contrary to any provisions of any Malaysian written law. And 3. The application is suitable to local circumstances. Non-related factual disputes were ignored for this question. Decision on the issue. The High Court ruled in favor of the plaintiff. The High Court held that it does have the power to order a DNA test on a child by relying on English common law. As applied through Section 3(1) of the Civil Law Act 1956, the judge exercised the court's inherent jurisdiction as parens patriae, meaning the court acts as a guardian to protect the welfare of children. Since no Malaysian statute governed this situation, the court lawfully turned to English common law principles to fill the legal gap. Ratio decidendi. The ratio decidendi, or legal reasoning, can be summarized into 3 key points. First, legitimacy and paternity are not the same. A child may be legally legitimate under Section 112 of the Evidence Act 1950, but that does not prevent an inquiry into biological paternity. The statutory presumption of legitimacy is not absolute. Second, there was no written Malaysian law that prohibited the court from ordering a DNA test on a child in civil proceedings. Because of this gap, the court was allowed to apply English common law under Section 3 of the Civil Law Act 1956. Third, under English common law principles, courts have the inherent equitable power to order DNA or blood tests if it is in the best interests of the child. In this case, the court found that the child has a right to know her biological origins and DNA testing is the most accurate way to resolve the issue. Therefore, applying common law was necessary, appropriate and consistent with child welfare. Stare decisis. Under the doctrine of stare decisis, this High Court decision is binding on lower courts and persuasive for future High Court cases involving similar legal gaps. Firstly, the court also relied on earlier Malaysian appellate decisions. This case references the decision of the Federal Court in Tony Pua Kiamwi v. Government of Malaysia, and another appeal, 2019-12 MLJ1, held that common law is applicable in Malaysia, subject to the proviso in S31 of the CLA 1956, unless the common law has been modified, varied, or abrogated by written law. Besides, the courts also adopted persuasive English and Indian authorities, even if the common law of England was not in force. Malaysia by reason of S31 of the CLA 1956, the case laws of England and India regarding the subject that are of persuasive authority in Malaysia, the Supreme Court of India, in Sharda Vidarmpal, Kutam Kundu and Papani Prasad Jena, and the English Court of Appeal in Riel, an infant, as well as in BR v. BJ, all arrived at the same ruling in which they held that the courts have the power to make an order for a child to undergo a DNA test or blood test to determine his or her paternity. Furthermore, the courts also applied established common law principles on parents' patria jurisdiction, based on the common law of England and under S31 of the CLA 1956. The courts in Malaysia pursuant to its inherent jurisdiction as parents patriae, which means that the court has the power to act as a parent to any child. Thus, the courts in Malaysia may extend its inherent jurisdiction as parents patriae to fill in the legislative void to order a DNA test on a child to determine his or her paternity. This case strengthens the position that Malaysian courts may develop the law using common law and equity, as long as they act within the limits of Section 3 of the Civil Law Act 1956. Overall judgment and significance. In conclusion, the court ordered that the High Court exercised of its inherent jurisdiction as parents patriae to order the child to undergo a DNA test to determine its paternity in any proceedings where it was in the best interest and welfare of the child, given that there was no written law in Malaysia presently governing the matter. If Cass was confirmed as the biological father, further orders could be made in a way that protects the child's emotional welfare. The court was of the view that the child had the right to know who her biological father was, and that the only way the child's paternity could be resolved conclusively was for her to undergo a DNA paternity test. Despite the defendant's argument that the child was raised and brought up by the defendants, and therefore raised with the knowledge that they were her supposed biological parents, it still did not serve to be a strong enough reason for the child not to take the test. If the results of the test shows that the plaintiff was indeed the biological father, then it would be in the best interest of and welfare of the child that the plaintiff be gradually reintroduced back into her life, under the guidance and advice of a qualified child psychologist, with experience in the disclosure of the biological origins or parents of children. Overall, this case clearly demonstrates the extent of application of common law and equity in Malaysia. It shows that common law is not automatically applied, but it can be used to fill gaps in Malaysian law, especially where justice, fairness, and child welfare are involved. Cass v. MPPL and Anor confirms that Section 3 of the Civil Law Act 1956 remains a living and powerful gateway for the Malaysian courts to apply English common law principles when necessary. After having examined how common law and equity were applied in a family and child welfare context in Cass v. MPPL and Anor, we will now move on to the second case. The next case, PT Karya Sumiden Indonesia v. Ocean Masters Marine Services, SDN BHD and Anor, will show how Section 5 of the Civil Law Act 1956 is applied in a commercial and maritime setting, highlighting the flexibility of common law across different areas of Malaysian law.
Brief facts of the case. The parties in this case consisted of the plaintiff, PT Karya Sumiden Indonesia, KSI, was in a contract of carriage via the sea with the second defendant, Sapphire Line Private LT, who acted as an agent, evidenced by 3 house bills of lading, issued by the second defendant, naming the plaintiff as the shipper and Jawad and Malik Metal LLC, JMM, as the consignee. The first defendant, Ocean Masters Marine Services SDN BHD, which was the carrier, was an undisclosed principal, revealed only after cargo had been lost. KSI had sold copper rods carried in consignments to Jawad and Malik Metal LLC, JMM. It was on free on board, FOB terms, and the cargo was sold on a document against payment basis. However, they were wrongfully released at the port of delivery, without the original house bills of lading. The goods were instead released at the port of delivery of Damam, against switch bills of lading issued at the behest of JMM by Super Express Cargo, which likely allowed JMM to avoid payment to KSI, causing the plaintiff to experience a massive financial loss. Because of this, KSI sued the defendants, claiming they acted in breach of contract. Legal issue related to common law and equity. The main legal issue that in this case, relevant to common law and equity, was whether KSI had the locus standi to sue for breach of contract of carriage despite the existence of the rights provided under Section 1 of the Bills of Lading Act 1855. Decision on the issue. The High Court held that KSI has standing to sue under the Bills of Lading Act 1855 with the application of Section 5 of the Civil Law Act 1956. Section 1 of the BLA 1855 has the purpose of the transfer of contractual rights under a bill of lading to an endorsee or a consignee, allowing them to sue the carrier in place of the original shipper. However, since there was no endorsement of the bill of lading to JMM in this case, KSI remained the original contracting party with the carriage. The court ruled that Section 1 of the BLA 1855 did not divest KSI of its right of action in the circumstances of the case. Thus, the contract of carriage between KSI and Ocean Masters remained, giving the plaintiff full contractual rights to enforce their claims against the carrier. Ratio decidendi. The ratio decidendi to this ruling is that the BLA 1855 does not automatically transfer contractual rights unless an endorsement occurs. The BLA 1855 transfers rights of suit to a consignee only when property in the goods has passed to that consignee. The BLA 1855 was enacted to address privity of contract issues and facilitate trade by allowing transferees of bills of lading to enforce contractual rights. However, in the absence of an endorsement, the shipper retains all contractual rights under the bill of lading, including the right to sue for any breach by the carrier. Section 5 of the CLA 1956 permits the application of English commercial law in Malaysia, reinforcing the binding nature of the BLA 1855 in determining contractual rights under a bill of lading. On the facts, the parties intended that property would pass only upon payment, as the transaction was on a documents against payment basis. Since JMM never paid and never obtained the original bills of lading, property did not pass, and therefore the statutory transfer of rights under Section 1 of the BLA 1855 did not operate. Consequently, KSI retained its common law contractual rights to sue the carrier, stare decisis. The High Court relied on established English common law interpretations of the Bills of Lading Act 1855 BLA, as well as English and Singaporean cases that related to the issue at hand. In the case of Samsung Corp v. Devon Industries SDN BHD 1996, 1 SLR 469, a decision of the High Court of Singapore expressed that construction of the contract between the parties is that they did not intend for the defendants to acquire title to the goods or the documents before they made payment. While applying in this case, the parties clearly intended property or title to the cargo to pass to JMM only upon payment of the purchase price. The English Court of Appeal case of Borealis AB Vistargas Liltiar, the Berg Caesar 9 QB 863, stating that Section 1 of the BLA was passed to remedy the situation of a buyer of goods being unable to sue or be sued on a contract of carriage made between the shipper and the carrier, even where a document of title and goods had been transferred to him. In this case, JMM never paid the purchase price, and so the title never passed to them, therefore allowing KSI to sue the defendants. Malaysian courts continue to follow English common law principles on the transfer of contractual rights under BLA, particularly where local statutes are silent or incomplete. Under Section 5(1) of the Civil Law Act 1956, matters involving partnerships, companies, banking, agency, transportation by air, land or sea, insurance, and commercial law are to be decided using the same law that was applied in England at the time. This act came into force unless a Malaysian written law provides otherwise. Since Malaysia has no specific law, under commercial matters regarding bills of lading, the use of English common law was allowed in this case. Overall judgment and significance. In the end, the High Court allowed the plaintiff's claim. The defendants were held liable for breach of contract of carriage and bailment. KSI successfully established its claim against both the defendants, who now had to repay the financial loss experienced by KSI due to this incident along with interest. KSI is also entitled to the costs of this action from Ocean Masters in the sum of 80,000 only. This is significant as it affirms that the Bills of Lading Act 1855 does not automatically extinguish a shipper's right to sue merely because a consignee is named. Where property in the goods has not passed, the unpaid seller and shipper retain standing to sue for breach of the contract of carriage under Malaysian law. It also emphasizes the significance of Section 5 of the Civil Law Act 1956 in Malaysia, as it allows for the usage of English common law in commercial matters, especially there is a lack of Malaysian law governing it. Thus, it only confirms the importance Section 5 of the CLA 1956 plays in the legal system of Malaysia in the means of business.
To conclude, the two cases discussed in this video clearly demonstrate the extent of application of common law and equity in Malaysia under Section 3 of the Civil Law Act 1956 in CS, VMPPL and ANOR. The court applied English common law and equitable principles to protect child welfare and justice in a situation where there was no specific written Malaysian law. On the other hand, PT Karya Sumidin Indonesia v. Ocean Masters, Marine Services SDN BHD, ANOR illustrates how common law principles are also relied upon in commercial and maritime disputes, particularly to supplement contractual and statutory gaps. Together, these cases show that while Malaysian courts prioritize local legislation, common law and equity remain important sources of law, applied carefully and selectively to ensure fairness, consistency, and legal certainty.